Welcome everyone. In this session, we'll unpack one of the most examined topics in evidence law, the hearsay rule. We look at what counts on hearsay, why it's generally excluded, and how the Evidence Act creates practical exemptions that reflect reliability and fairness. Let's begin with the heart of this topic, the rule against hearsay. Under Section 59 of the Evidence Act, evidence of a previous representation made by a person is not admissible if it's used to prove the truth of what that person intended to assert. In simple terms, if you tell the court that someone said something, and you want that to stand as proof that something actually has happened. That's called hearsay. The reason is reliability. The original speaker isn't in the court to be questioned. Why do we exclude hearsay? Think about what happens in court. Witnesses take an oath, they are cross examined, their tone and expressions are assessed. None of that happens when the original speaker isn't here. In Teper versus the Queen, hearsay was called not the best evidence. The rule protects fairness by keeping untested statements out. In Teper versus the Queen 1952, the rule was described as fundamental. R versus Blastland 1986 added that hearsay's problem is assessing weight. Jurors can't test the credibility of unseen declarants. The Uniform Evidence Acts narrowed hearsay to intended assertions and added more structured exceptions. A representation isn't limited to speech. It includes gestures, writing, or even silence, implying agreement or denial. The act captures anything conveying meaning. In Lee versus the Queen in 1998, the High Court said representation includes conduct. R versus Rose 2002 showed that silence by students implied a fact that they hadn't seen the suspect and was therefore hearsay. As previous representation is a statement made outside the proceeding, whether in earlier proceedings or conversations. If it's offered to prove the truth of what was said, it's hearsay. If it's just to show it was made, it may be admissible. The Act applies only to human made statements. Machines or animals cannot intend to assert facts, so their signals like a red light, camera flash are not hearsay. When a prior statement is offered as evidence, the question is purpose. If used for truth, hearsay. If only to show it was said or affects someone's state of mind, it's admissible. Context determines admissibility. If a witness says, X told me they saw D leave the victim, and it's used to prove D actually left with the victim, it's hearsay because X isn't in court for cross examination. Section 59 applies to intended assertions. If a child says, Hello, Daddy, They are not asserting paternity. But if someone says, "This is Pablo," that's asserting identity and can be hearsay if offered to prove it. Sometimes statements are admitted to show their effect, not truth. In Subramaniam versus Public Prosecutor 1956, terrorist threats were admissible to show the accused's state of mind. Coercion, not the truth of those threats. Section 60 allows evidence admitted for a non-hearsay purpose to also be used for its truth, but courts may limit that under Section 136 to avoid unfair prejudice. In R versus Matthews, the accused's diary entry, "Liz dead," was admitted to show he knew before it became public, implying guilt, not to prove the death itself. Same principle, relevant for effect, not truth. A document includes anything recording information, writing, figures, photos, or digital storage. The Evidence Act reflects modern information forms from paper to electronic media. Section 48 provides multiple ways to prove a document: tendering the original, a copy, or a certified extract. Section 51 abolished the common law best evidence rule, so copies are acceptable if accurate. Under Section 48(1)(d), information stored digitally can be proven via printouts or transcripts. In Butera versus DPP, the High Court noted that the evidence is the recorded content, not the physical medium. Section 50 allows summaries of large sets of documents to be tendered for convenience, provided the other side can inspect originals. It keeps trials efficient without losing fairness. Documents are representations in writing. Tendering a document to prove its contents, truth is hearsay unless an exception applies, such as business records or admissions. Section 69 exempts business records made in the ordinary course of businesses, relying on personal knowledge. Sections 70 to 75 extend exceptions to labels, electronic communications, reputation, traditional laws, and interlocutory proceedings, balancing reliability and practicability. Thank you for watching and engaging in this topic. Remember, mastery of evidence law, like success itself, is about persistence, the courage to keep learning and refining your understanding. Good luck. See you in the next lesson.